This is Montesino Law!
Montesino Law, yes, y'all. Armando Montesino, do it like a boss.
Welcome to our second video. Today we're going to talk about commercial collections. Specifically, we're going to talk about demand letters. But first, I'd like to point out one thing for our viewers. My firm only does commercial collections. We do not handle consumer collections. If you've been getting calls or getting sued regarding a credit card debt, please do not leave us nasty, angry comments accusing us of harassing people who are down on their luck. If you are being harassed by creditors or collection agencies, you have rights under federal law, and depending on where you live, you may have additional rights under state law. We will cover these protections in a future video. Now, going back to the topic of today's video, I categorize demand letters into three types. And for the reasons that follow, you'll see why it's important to try to send the best type of demand letter that you can. The first type is the demand letter written by a non-lawyer. That type of demand letter is often not very effective. They don't tend to get a lot of response, no matter how well written they are. And for that reason, they can best be categorized as why. Because people know that you haven't gotten serious about collecting this debt. They know that you haven't taken the first step, which is hiring an attorney. If you're sending the demand letter on behalf of a corporation or an LLC, you legally can't bring suit without being represented by an attorney unless it's small claims. By sending your own demand letter, you are letting them know that you won't be bringing suit anytime soon. The second type of demand letter is the demand letter written by an attorney. These are more effective. They let the other party know that you have taken the step of hiring an attorney. However, these often get ignored as well. Sometimes people will pay you because they really hate litigation. They don't want to be involved in a lawsuit, or they think that it's embarrassing. However, as I said, they often get ignored. There is a good chance that you won't get paid until you actually file suit, even if your attorney sends a demand letter. Some debtors, those who really don't want to pay you, may see an advantage to waiting until after your attorney actually files suit. Why? Because let's say they owe you $10,000. Well, they might believe that there's a 50% chance that you will actually go through with suing them. So the expected value to them of this lawsuit is the $10,000 times the 50% chance. They see it as a threat, an expected threat of $5,000. But to pay you, they'd have to take out $10,000 actual dollars. For that reason, you might not get paid until you actually file suit, even with a demand letter by an attorney. Now, the third type of demand letter is the demand letter with legal consequences for not paying within a period of time. The law provides, in many cases, for enhanced penalties after a demand letter is sent and there is no payment within the time specified in the statute. One example is Florida's civil theft statute. If the debtor obtained your property by fraud or other specified acts, then if you send them the demand letter, and they don't pay you within the specified period of time, in this case 30 days, they are liable for 3 times the amount that they owe you. This is known as treble damages. Another example is Florida's bounced check statute. If you send the demand letter as specified in the statute and they don't pay you within 30 days, they are liable for the principal amount plus treble damages. For example, if they bounce a $2,500 check and they don't make good on it within 30 days of your letter, they are now liable for $10,000. But wait, there's more. In both of these cases, if they don't pay within 30 days, you are also entitled to attorney's fees even if your contract did not provide for them. The statute provides for them. Now, you may be thinking, if I win the case, aren't I entitled to attorney's fees anyways? Well, the American system, Florida's system, provides that in a lawsuit, every party carries the responsibility for paying their own attorney's fees in the absence of a statute or a contract that provides otherwise. By sending this letter and them not paying you within the 30 days, you have now shifted the responsibility of paying for the attorney's fees from you to them. These letters are incredibly effective, and for that reason, I categorize them as very scary, and for good reason. Now, we hope you enjoyed this second video of ours. If you do have an actual legal matter and you're not watching this for the purpose it was created, for educational purposes, then hire a lawyer. That being said, if you're enjoying the channel, you'd like to support it, please hit the subscribe button below, and we look forward to seeing you next week.